Can one of the partners or owners of the property force the sale of your house in Ontario? Imagine this. Sarah and her brother Mike inherited a beautiful house in Ontario worth $900,000. Sarah wants to sell. Mike said, "No way, I'm here to stay forever." So can Mike stop the sale? The answer might surprise you. So watch the video. Ontario law actually has something called Partition Act. And here is what every homeowner should know when they own the property either under joint tenancy or tenancy in common with other partner. Number one owner can ask the court to force a sale. If you co-own a property and can't agree, one owner can apply to the court to have the property sold. Number two, you don't need the other person's permission. Mike can't simply say, "No, I want to live here forever." Sarah can start the court proceedings without his approval. Number three, court usually orders the sale. Ontario judges generally believe people shouldn't be forced to stay in a property partnership that no longer works. But there are some exceptions. Number four, a judge may delay or refuse the sale of the property if someone is acting in bad faith, there is a dispute over who really owns their shares and how much, or selling would seriously harm children or create unfairness. Now here is where things get interesting. Number five, equal names on the title doesn't always mean equal money. Suppose Sarah paid the down payment, most of the mortgages, property taxes, and she spent $80,000 renovating the house. The court may side with Sarah, which deserves a larger share of sale proceed. Number six, living there for free could become expensive for Mike. If Mike stayed in the house alone while preventing Sarah from using it, the court could order him to pay Sarah what's called occupational rent, basically compensation for their exclusive use of the property. Number seven, the smart solution. Instead of spending thousands of dollars in litigation and lawyers, Mike could simply buy Sarah's share if he qualifies for the mortgage and financing. It saves everybody time, stress, and money. Number eight, court aren't the cheapest. When the owners argue over contribution, property values, or ownership percentage, legal fees can add up quickly. And some of these cases may drag for 6 months, 1 year, or 18 months to 2 years as well. Negotiation or mediation is much better choice. Number nine, keep every receipt. Mortgage statements, bank transfers, renovation invoices, and property tax bills. These documents could mean tens of thousands of dollars when it's time to divide the money and property. And finally, number 10, very critical, get professional advice early. An experienced Ontario real estate lawyer and a knowledgeable real estate broker can often help you understand your options before the conflict becomes an expensive courtroom battle. So remember, just because one co-owner refused to sell doesn't always mean house can't be sold. Ontario law gives co-owners legal options, but every case depends on the facts. Hi, my name is Singh. I'm broker of record worth fortune to reality. I create easy to understand videos in regards to Ontario real estate. I discuss sometimes court cases and home ownership and tips for buyers and sellers. Follow me on TikTok, Instagram, YouTube so you don't miss the next tips and could save you thousands of dollars. This video is purely for educational purposes, not a legal advice. Thanks for watching.